Okay, I think we can get started now. Welcome back, everyone. I hope you had a good coffee and were able to meet some new folks during our networking session. So we're here for the last session of World Arbitration Update 2024 China Insight. And for any of those folks who are just connecting online and are new, this is part of the World Arbitration Update Conference, which will be going on for the next week in various locations around the world. But for now, we have our 8th session, which is titled, What is the Evolution of Third-Party Funding and Litigation and Arbitration in China? Now, third-party funding has been a major topic of conversation in the international arbitration community for a number of years. It really is an innovation in how to finance international disputes and has resulted in the growth of a number of firms who provide this kind of support, whether for litigation or arbitration or even investor-state dispute settlement. And we have the privilege today of an excellent panel who are going to talk to this issue. Our moderator is the co-founder and my colleague, Dr. Jose Antonio Rivas. Jose is the founding partner of X Strategy LLP. He's an adjunct professor at Georgetown. He did his LLM and SJD at Georgetown Law School. It was a former negotiator of trade treaties and investment dispute provisions for the Colombian government, and also spent some time working in the third-party funding field a few years ago. So he's a perfect person to do this panel. And I'll thank him and pass over the microphone to begin our session 8 on third-party funding.
Thank you, Ian. And this is our last panel, and we have the great privilege of being with a esteemed number of panelists who are practitioners, but also third-party funders. And before going into introducing our panel, I would like to give a little bit of background in terms of third-party funding. The third-party funding seems to be quite novel in investment arbitration and also in international commercial arbitration and also in litigation. The truth of the matter is that third-party funding is not that new. It has been there for a while. It has been there with different names, and part of the issue and part of the job when one is educating about third-party funding is to demystify this notion that it's obscure or strange. Third-party funding can happen by an institutional funder, which would be a company that funds litigations or cases in exchange for a percentage of the award or of the damages that the tribunal or that a judge decides to rule on and grant to the claimant. But third-party funding can also happen by a law firm that signs with a claimant a contingency fee, or it can happen also by the aunt of the claimant that gives his nephew or her nephew some loan, either for interest or without interest. So third-party funding is not a strange and extraterrestrial notion. It's way more simple to understand than anything else. With that, I am very honored to present our speakers, and I will take some few seconds. First of all, we have Miss Hang Wong, who is a partner of the Global Law Office, and she has had experience in cases and written about third-party funding. And our collection here of experts is such that that many of them have written on third-party funding, and they have analyzed the issues on third-party funding, both related to litigation funding in China, but also into arbitration funding in China. And the interesting bit is that because it's such a vast economy, I believe that this panel would be one that is incredibly educating, not only for Chinese lawyers, but also for lawyers that are abroad. Second, we have Chung Lao, and who is an investment manager of Omni Bridgeway. And hopefully, Chung, you're with us. And also we have Amy Wen Wei, who is a counsel at CMS, who has also had experience in the subject matter, and we are incredibly lucky to have Amy with us. And following Amy, we also have partner Yu Yao from Hua Mao and Gui Gu Law Firm. And like our other speakers, Yu is a partner that has practical experience and knowledge in third-party funding, and thinks about these issues both from a practical perspective and also a theoretical perspective. And finally, we will have Senior Vice President of Haosu Capital, which we're extremely lucky to have him. Basically because there is, like our other speakers, practical experience on how to use capital for litigation and arbitration. And without further ado, I would like to give the floor to our presenter. So welcome. Yes, go ahead.
Good afternoon, everyone. It's my honor to be here to present on this topic, the development of third-party funding in China. Well, TPF has long been a hot topic in dispute resolution, especially international dispute resolution. Well, you can see from the PPT that what I will cover in the next few minutes, including a brief introduction about the rise of local funders, then some of the landmark case involving TPF, and also a brief introduction of TPF, the introduction of TPF into arbitration rules relevantly adopted by the arbitration institutions in 2024 this year, and also some of my personal thoughts about this topic if the time allows. To start with, about the rights of local funders. Actually, today we have the specialized professional for the local funders. So I will just cover a little bit about this part. The emergence of local professional funders in mainland China can be traced back to 2015. We can see that there are several famous local funders now, such as Hoju Capital, DS Legal Capital, Ding Song, WCC Litigation Investment, Bangying, and etc. Most of these local funders are established by Chinese lawyers and other legal professionals and business intelligence with a wealthy experience in dispute resolution. Well, for the next, I would like to make an introduction about those landmark cases in arbitration and litigation in recent years, which will illustrate Chinese court's position on the legality of TPF in arbitration and litigation. Well, as arbitration proceedings are confidential, it's quite difficult to determine which cases are actually funded unless the award is subjected to national court's judicial review. Then in 2022, 2 CTAC awards involving TPF were challenged and subject to Chinese courts for judicial review during the non-enforcement proceeding as well and the setting aside proceeding. In such case, the claimant in the arbitration proceeding actually secured TPF to initiate arbitration. And the party had already argued on the legality of TPF during the arbitration proceedings, and the tribunal concluded that the claimant has not violated any laws or arbitration rules by securing TPF to initiate arbitration. Then during the judicial review proceedings, the court also held that Chinese law does not prohibit TPF for arbitrations, and parties are entitled to secure such funding. Well, this case demonstrates that Chinese courts take a similar approach to TPF for arbitration as international practice, indicating that TPF for arbitration is permissible in mainland China. Well, the legality for TPF for arbitration case has been confirmed by the court. The legality of TPF for litigation is disputed, especially if we try to get some clues, if not conclusions, from the recent case in 2022 and 2023. We can see that the legality of TPF for litigation has been seriously challenged. Among those cases, the most famous one is the case tried by Shanghai courts in 2022, the Anders Scott case in this slide, this one. This case has been selected as one of the representative cases for 2022 by the Shanghai High Court. In this case, the funder tried to claim from the funded party of the payment of process of the funded case, which should be payable under the litigation funding agreement. Although the Shanghai courts recognize that litigation funding is a new matter and that is no clear provisions prohibiting or permitting it under Chinese law, the courts deemed the litigation funding agreement contrary to public order, public policy, and good morals, and that's invalid. Therefore, the funder was not entitled to the process of the funded case. About this case, the court actually made a very comprehensive and thorough analysis about TPF for litigation in its judgment and raised this serious concern about the nature of TPF. Though this case is not one of the guiding case or the gathered case selected and reported by the Supreme People's Court, which have certain force on the future case, but the findings and the conclusions, to my understanding, are still likely to have a very profound impact on future court decisions regarding litigation funding. Well, about this case, I will stop here, and I think my dear colleagues, panel members, will discuss more later during the following panel discussion. Yeah. Despite of this case where legality of TPF for litigation is denied, there have been other cases in which other courts have reviewed the legality of such agreements with similar nature and reached completely different conclusions in earlier years. For instance, in 2021, the Songjiang District Court of Shanghai reviewed the legality of a litigation funding agreement in a contract dispute filed by the funder against the funded party. The court issued a favorable judgment to the funder, affirming the legality and validity of the funding agreement, actually. Yeah, based on the above, it's evident that the Chinese courts have adopted divergent approaches with respect to TPF in the context of arbitration and litigation. TPF for arbitration is well embraced, while when it comes to TPF for litigation, the accent case are split on the questions of its legality. In addition to those landmark cases here, the next one I would like to cover is the introduction of TPF into arbitration rules by arbitration institutions in mainland China in 2024, such as we can see that CTAC rules and SHIAC rules. Well, one of the notable features of CTAC 2024 arbitration rules, which have already took effect since the 1st of January 2024, is the explicit inclusion of provisions concerning TPF in its Article 14.8. You can see the full paragraph of this article. Well, Article 48 addresses mainly two aspects concerning TPF. The first one is the disclosure obligations. The rules distinguish between proactive and upon request disclosure. And the second one is consideration of TPF in cost allocation. You can see the second clause, the second paragraph empowers the arbitral tribunals to consider TPF when deciding arbitration costs and associated expenses. In addition, Shanghai International Arbitration Center also adopted new arbitration rules in this year, and the Article 13.5 addressed the TPF as well, but just from the disclosure perspective. Well, in addition to CTAC and SHIAC, other arbitration institutions here in mainland China have also recognized the importance of addressing TPF in the arbitration rules. Well, such as BAC, also the China Maritime Arbitration Commissions, the Shanghai Arbitration Commission, and etc. This trend reflects a proactive approach by arbitration institutions in mainland China to adapt to the evolving landscape of dispute resolution and provide guidance in TPF-related matters. Well, the last topic I would like to address a little bit actually is my personal thoughts on this topic. Actually, reflecting on our experience, we have represented clients in relation to arbitration case involving TPF as well. This including acting for claimants seeking TPF and also defending respondents in case where the claimant had secured the TPF to initiate this proceeding. But I think for the time, due to the time constraint, I can leave it to the panel discussion later. And now I will give the floor to our panel members for further introduction or the insights and sharings. Thank you.
Thank you very much. So now we turn into the question of a little bit more deeply what what is third-party funding, and how does it work? How does it work to actually reach a funder, make as counsel or as a client that has a case? How do you go to them, and what is the process of litigation funding and also of arbitration funding if you are the lawyer of a company that may have a litigation and for specific reasons your client is looking for funding, either because they want to diversify the risk or because there is some need of capital. How could you conduct that process? And for that, we have in Singapore, Mr. Chung Lao, and please take the floor. Chung?
Thank you, Jose. Can you hear me?
We can hear you and we can see you now. Yes.
All right. Thank you very much. So I think it's quite a lot of ground to cover, and I know Wang Lishi has also spoken about the recent developments, but I think maybe what I want to give today is a bit more of the third-party funders' perspective and also our perspective of funding cases in the PRC and for PRC clients. So I mean, just taking one step back and talking about what third-party funding is, and Jose has very rightly pointed out, it's existed for a very long time. Lawyers have acted on contingency fees. You know, someone's aunt might lend their nephew money and charge interest on that. So that's also third-party funding. But I think in modern commercial context and in the global industry context, it's basically the concept of a third party, a non-interested party who is not a party to a litigation or an arbitration, providing the capital and the financing to pursue a litigation, to pursue an arbitration and the subsequent enforcement and recognition if necessary. And in exchange, that third-party funder would typically ask for a fee upon success. The arrangement for most funders, and that's like Omni Bridgeway, is provided on, the financing is provided on a non-recourse basis. So that means if you don't win the case, and winning means you must collect the money, there will be no fee that's payable. So even if if a claimant loses the case, then what happens is that the funder bears the entire cost of the experience and maybe even the adverse cost, depending on what the agreement specifies. So and as I said, success really only means when a client or claimant actually receives money in the bank. Obtaining a judgment or award doesn't really count for anything. It's just an expensive piece of paper unless you actually successfully get money in the bank. So in most cases, funding is provided on a full basis, i.e. the funder covers 100% of the costs, legal costs, arbitration fees, court fees, expert costs. But there are cases as well where we can provide partial funding. Sometimes clients just want half of the amount. They just want to de-risk a little bit, and therefore the funder's returns are lowered. So the concept of third-party funding is really, you know, as Jose mentioned, a tool that companies can use and lawyers can introduce to their clients as to help their clients risk manage, much akin to an insurance product to some extent. Because you are having a third party pay for the cost of your arbitration or litigation, and they are bearing the risk, right? And if it's successful, then you're sharing the risk, sharing the fruits of the litigation or arbitration with them. So I think that covers what third party funding is, and I think Jose also mentioned a question earlier about, you know, what do third party funders look at when assessing any case to decide whether or not to fund a case. And so Omni Bridgeway has been doing this for the past 38 years globally, and we've been also doing it. And I think really one of the global litigation funders who have taken the Chinese market very seriously. So just to start off, I would like to say that there is no one size fits all criteria to determine whether or not we want to fund a case. Every case is different and has to be assessed on its individual facts. But there are three main criteria that we would assess. One, the merits of a case. Two, the recoverability, and then the third, the economic viability of a claim. So I'll start with the merits, and I'll explain why it flows in that way. So obviously, a third-party funder only receives its payment, its success fee upon a successful outcome. So we would only want to find cases that we expect to win. We typically say that we expect based on assessment of all the different factors, legal advice provided by the lawyers, the factual circumstances, the documentary record that we've been provided with, that the claimant has a more than 70% chance of success. Although this might seem very clear in most cases, and lawyers come to us and say, we've got reasonable prospects of success, we believe it's 70% chance of success, it's sometimes not that easy to assess. Particularly, you could win a case, contractually you're entitled to damages, but a lot of the time the question is, how much do you win by? Because a 10 million judgment or award, it's very different from a 50 million or 100 million judgment and award. And this ties into my next factor that I will talk about later, which is the economic viability of a claim. The second criteria that we would consider is the recoverability. This is something that sometimes the clients are not very aware of. Lawyers sometimes don't think about this at the outset of the case, although I do have to say more and more so this is something that is at top of mind. This is something that can be quite tricky to assess. As I mentioned earlier, a good judgment or an award for say 50 million, 100 million USD doesn't really mean anything. It's just an expensive piece of paper unless you can extract cash from the counterparty. So at Omni Bridgeway, we have an in-house asset tracing team across the globe in Europe, Singapore, as well as in North America, who helps to assess that. We also sometimes rely on third-party asset tracing companies to assist with the asset tracing process to identify potential assets of the counterparty. Essentially, there are two big things that we want to consider in every case on the issue of recoverability. One is whether the counterparty can pay, and two, whether they will pay. The first one, if they can pay or cannot pay, I think that's quite clear. If they are insolvent or close to insolvency, then that's something that we will probably not be able to fund. But if they can pay but won't pay, that's something that we can probably come up with strategic solutions to consider whether or not we can get them to pay, i.e. sometimes they might think that they are untouchable in their own backyard, but what we can do is to assist clients to consider whether there are assets in more enforcement-friendly jurisdictions that can assist in getting them to the settlement table. And then the last point, last criteria is economic viability. And the typical rule of thumb for most litigation funders around the world is 1 to 10 rule, i.e. you don't spend more than 10% of the realistic claim value on pursuing the claim. And the rule is in place really because we don't want to end up having a situation where a funder takes up the majority of any recovery proceeds. So if you spend more than 10% of the claim value and then you end up only getting, end up having to split that, if you end up spending say 20% of the claim value and then the funder's success fee is 30%, then you end up in a situation where the client only gets 50% or less of the claim. And so that's something that we want to avoid. That's why it's very important to assess the 2 points that I mentioned earlier, the merits and the quantum of the claim, and also the recoverability, how much you expect to be able to, at the end of the day, extract from the counterparty. Now, I think I'll turn specifically to the PRC market and why it's interesting to third-party funders. As one of the world's largest economies, if not the largest economy, the Chinese market is always going to be interesting to any legal practitioner or third-party funder. Particularly in the last 10 years with the Belt and Road Initiative, you see many PRC companies investing significant monies outside the PRC, often in jurisdictions that are they're very different from the local PRC market in the developing world, in Africa, in Southeast Asia, in Central Asia. And we at Omni Bridgeway, as I said earlier, we are one that really takes the Chinese market very seriously. We have funded multiple cases in the PRC for PRC clients, and also and the case that Wang Lyshi talked about earlier, the one before the Beijing Fourth Intermediate People Court and the Wuxi courts, that was a case that was actually funded by Omni Bridgeway, then IMF Bantam. And so we are willing to break new markets because we see that there's a huge potential in these markets. And so the Chinese market is definitely one that we do not want to ignore. And we see actually that the recent trends in the PRC market actually point in that direction. And the proof is in the pudding. We've got many local PRC funders coming up in the market. But more and more so, we are seeing large PRC corporates like SOEs as well, approaching us for assistance in third-party funding for cases outside the PRC. Particularly, and quite a lot of what I've seen in recent months is to assist with the recovery of non-performing loan portfolios. Large AMCs and banks have claims against, they've obtained judgments or awards against individuals who have absconded from the PRC, and they need assistance to enforce that outside the PRC. And that's where global third-party funder like Omni Bridgeway can assist. In one such case that I looked at, the one issue was security for cost. That's something that we could easily have dealt with because Omni Bridgeway had a presence in that jurisdiction, and we could provide a guarantee that we would cover that adverse cost. So that's something that I think is one big trend that we are seeing. And of course, as I mentioned earlier, with the large investments outside the PRC, we see that sometimes these projects do go wrong, and big PRC companies need assistance with international arbitrations, commercial arbitrations, or investor state arbitrations outside the PRC. And that's where, and those tend to be very costly. And that's where a third-party litigation funder like Omni Bridgeway can help to assist. Yeah.
Well, Chi Chong, thank you so much. I mean, I know that you did pack quite a bit. This was more than an elevator interview, and you know, congratulations for putting a lot of material and information there. You talked about the quantum, the importance of having a winning case, as well as the cost. So I think that this was a very substantive and summary introduction to third-party funding. Now, you know, as a moderator, I you know, I have sort of some prerogatives to change a little bit our schedule because we have a newcomer, Mr. Liang Yu, and who is also in third-party funding. I would switch a little bit our order and have his feedback concerning third-party funding from a somehow different perspective. I would invite Mr. Yu to comment on first further comment on the developments and regulation on third-party funding in China, one, and two, on how you might see that third-party funding could support Chinese enterprises in their international expansion abroad. So, you know, two topics. One, the regulations in China, and two, how third-party funding can help state-owned companies, but also private investors expand their business outside of China.
Hoju is a China-based third-party funder. We just established 2 years ago, and we are new to the market. But actually, TPF is not a new concept, even in China market. As Ms. Wang said just now, the TPF in China carry on business from 2015. Many Chinese founders like Ding Song, like Bang Ying, they have existed on the market for quite a long time. I want to say why Hoju would want to step into this market. Just a little bit explanation on the sort of the founder. If you look into the structure of the founder of Hoju, you can see many of the founding partners are from distinguished dispute resolution law firm in China. They have over 30 years of experience in this market. They have already seen quite a lot of Chinese clients. They lost their case because of the poor litigation structure, or they lose the case because they don't have the enough capital to fund their legal cost. So they really want to share their experience, their expertise to help the Chinese clients. And also, they study and research on the notion of the TPF in the world, and also have quite a lot of communication with the international counterparts like Burford Capital, like Omni Bridgeway. So 2 years before they established this company. And in these 2 years, we can say we are very prudential on making investment, because although the concept of TPF is very hot topic these years, but Chinese market and Chinese legal system are different from international market. That's why we need to spend more time to explore the business model, to talk with different clients to see, to find out actually which kind of business model is good for our clients and also good for the founder. And the moderator said just now, I have 2 topics. Actually, I want to just skip the first topic because maybe Miss Wang and Miss Yao will talk more about the Chinese regulation region on TPF broadly. And I would maybe go to the second topic directly, and that's kind of share our experience on when we are approached by Chinese clients, when they have such kind of international disputes, they need the help from Chinese founder. I will share some insights on how can TPF can help Chinese company going abroad. Chinese companies going abroad are also a very hot topic in recent years. Chinese company will invest in doing business globally. You can reasonably expect the disputes will come across along with the business. Statistics show China ranks the 2nd largest dispute resolution market in the world. And we believe the amount of the international disputes cases are also rising. When the Chinese company, they face international dispute, when they have the case on the hands, what kind of difficulty they face? We summarize there will be first lack of money, and then lack of knowledge, and then lack of experience or expertise, and also lack of the capability to manage the case. Why do we say so? As we summarize, Chinese companies face asymmetry in three perspectives when dealing with international dispute. First, they have the information gap. They don't have, or they have limited ideas on the legal environment, legal system, the rules and regulation of the country where the case was situated. And secondly, they have the asymmetry in bargaining power. They don't have too many ideas to negotiate the legal fee with the foreign lawyers because they also have poor knowledge of the fee structure on how the foreign lawyers can provide it. They cannot talk like a discount with the foreign lawyer. And the third one is for the asymmetry in expertise. When they have already retained the lawyers, but they still have to make decisions on some professional questions. When they face such kind of questions, they don't know how to make a decision in some major milestone and in different stage, and they don't know how to monitor the performance of the foreign lawyers. We believe this kind of asymmetry actually make Chinese company, they are confused, maybe they are frightened or hesitate. When they respond to the lawsuit or when they have to make a decision to initiate the lawsuit to claim damages. So when the opportunity was missed, they might lose the case or fail to claim the damages. That's, I think, that the predicament faced by Chinese company. I mentioned 4 elements like money, knowledge, expertise, capability to manage, but we don't think the money is the first concern. Although we all know that for international proceedings, the legal fee or the legal cost is very high, especially in international arbitration. The fee sometimes amount to millions of dollars. For some Chinese company, they cannot afford that. But why we say it's not the first concern? Because even they have the confidence on winning the case, they can make some finance arrangement. But even they have the money, they still have the problem. They, as I mentioned just now, the information gaps, they don't have knowledge to select the lawyer. They don't have the knowledge to manage the case. So that's why I say Chinese founder with international vision can really help to solve this kind of problem. In our experience, a successful Chinese founder can have relatively sufficient fund to back the case. They also have the expertise. When I mention expertise, I would say that you really need a core team member who are the player in the market. They can make the decision based on their experience. And also, the success Chinese founder will know the Chinese market and Chinese culture very well. This will help the founder to establish or enter into business arrangement with the Chinese client. And lastly, the Chinese founder should have a very good relation with international resource and know the international law society very well. With this kind of advantage, Chinese founder can act as a bridge to connect the domestic demands with the international legal service, just like as I put the example, like adapter, yeah. And finally, I would like to also talk about the case management, because in addition to the money put into the case, because the Chinese clients maybe have no too many idea for the foreign law issues, so they really need Chinese founder to help in this regard. And with the case management, they help the Chinese company to select arbitrator, to select lawyer, and to negotiate the legal fee, and also to get case management in the process, and finally to get a good case, good award finally. I think that's what I want to share today. I think the time is almost there.
Thank you so much, Mr. Yu. I think that from what we have heard, it is quite evident now for this public, for this audience, that third-party funding has a huge potential, an obvious potential in the Chinese market. This is something that that perhaps wasn't that obvious a few years ago. I know that at some stage there was lack of information or misinformation in terms of the support, the legal support by courts concerning third-party funding, and there was a question mark based on the decisions that you have heard earlier on by Miss Hang Wong. This is something that is being clarified now. Now you have two funders, one which is a Chinese funder and one that is an international funder, who are conveying the same message. Now, based on what both Chi Chong as well as you have shared with the audience, I would like to give Amy Wen, who is at CMS, she's counsel, and who's with us remotely, to provide any comment that she may have with respect to what we have heard so far. 3 minutes.
Thank you, Jose. Can the audience hear me?
Yes, perfectly.
Perfect. Good afternoon to all. This is Amy. I'm based in Hong Kong since 2020. I'm from China, but I am a French and US qualified lawyer who's practicing in Hong Kong, which is also part of the Chinese market. And having heard the two speakers, I think from a counsel's perspective, I'd like to give some practical tips in a way for clients, having heard the two discussions just now. The first is, when you're a client facing dispute, wanting to start an action or an arbitration against an opposing party, what do you have in mind and what to consider when you select fundings, or even consider whether this is an option that your company would like to pursue? So based on what we just heard, you could have the impression that secure funding basically give you a risk-free option to free up the liquidity that your company would otherwise have to invest into commencing legal actions. This is to a certain extent true, in the sense that, like Chi Chung explained, the client, once the case is selected for funding, you do not need to bear the liquidity. And in case you do not recover any proceeds from the litigation, you do not need to pay back the funder. Well, most of the times this depends on the funding agreement, the fee that have already been advanced. There is always a price and a premium to pay, to enter into such agreement, and that's usually also on top of the fee that's recoverable by the founder. Other situations to bear in mind, such as whether the client would like to retain complete autonomy in deciding its own dispute strategy, in the choice of arbitrator, the choice of expert, the choice of counsel, as well as the basic way to manage and to run their entire case. So this is something that certain clients have stronger preference, and might be something that you need to compromise to a certain extent if a founder is involved in a process. And the second point, and it could be quite obvious to us doing this, but less obvious for clients, is that funding is not only available for claimants or plaintiff, the party bringing the action, it is also available for defendant and respondent, not only in cases where you have a counterclaim, which would be more obvious because you also have a claim, a title for damage against the other side, and that part of the dispute could be funded and carved out in a way from the rest of the dispute proceeding. However, even in cases where you're so defendant and do not have counterclaim, you could still be funded. It's less common, but not impossible. And this is particularly true for companies who think the claims are frivolous, do not stand a good chance against them, and they will be able to recover costs once the proceedings are through, and they would like to free up the liquidity while the proceedings are ongoing. And in that case, founders can still step in. Last but not least, I think it's also important to consider the type of dispute as well as the total amounts at stake. So Chi-Chung also mentioned this at the forefront. I think it's important to bear in mind, and you want to manage your case in a proportionate manner. So to consider the type of counsel you want to engage, the type of proceeding, whether it's litigation or arbitration, how much you would need to invest into the proceeding, both from a legal fee cost, but also from other costs and expenses relevant for the operation. And in terms of how that compared to the final recoverable proceeds from the dispute action. So the 1-to-10 ratio as a general rule of thumb, I think is a helpful guidance. It's not always true though, and it can really depend on the specific cases, which are also subject to negotiation between the party being founded as well as the founder. We've come across cases where the founders are willing to shoulder up a higher percentage of fees as compared to the total amount in dispute, or even a lower percentage. You could be dealing with cases where an expert's opinion is that the amount in dispute claimed could be inflated and does not reflect the actual recoverable amounts. So this is something also important for the users to bear in mind. Last but not least, and particularly relevant for Asian party, for Chinese party, is also that most companies are not very experienced dealing with founders or are not familiar with the general structure of the founding, including the fact that at the forefront stage of a proceeding, when you're in contact with a founder, you could already be required to provide a lot of information, documents to facilitate your counsel and in most cases, the founder, to be able to be in a position to assess the merits and the chance of success of your case, including recoverability. And these information sometimes are not readily available for the client, which can cause some delay when securing the funding agreement, and the missing of information from the opposing side, for instance, which may not come about until the document production stage, or the founder may not be willing to accept the risk which were presented before the case was initiated or before you review the submission of the opposing party, is also something that could potentially impact how the funding agreement can be concluded, and also how favorable the terms are for either the client or the founder. So I'm sure the speakers who follow up will touch upon these topics, but I think it's helpful, especially at the outset, to bear these factors in mind when you listen to the discussion of the other panelists, which will hopefully help you form a more educated opinion about the practice in general, and also when you are choosing whether or not to engage with a founder or whether or not to have funding for your particular case. Thank you.
Thank you, Amy. I mean, that was very enlightening also, especially from the council's perspective, and how I'm sure that you have, in some practical cases, counsel them as to the litigation funding agreements and what to underline when dealing with funders. I would like to now move on to Mr. Tao Kuang, and he, as we know, he's a partner of King Wood Mallesons, and his perspective is quite interesting because we are going to look into why third-party funding in China may be different from the funding in the Western market, and how clients in both may have a different approach. So, Tao, take it away.
Okay, thank you, Jose. So, good afternoon, friends on site and online. So I'm happy to join this panel, but to be very frank, I'm not an expert in this topic, and I also have no experience in working together with TPF in any real case. But as the managing partner of KWM, we were approached by funders, domestically or internationally, to discuss the possibility or the potential of cooperation. So I know something about the TPF, but for this time, I would like to share with you some of my understanding of some observations or understandings, in particular the challenge for TPF in Chinese market. Okay, maybe it's not correct, but I want to share with you my thoughts. First of all, the contingency fee structure. And I understood that the TPF, one of the important functions is to release the burden or the concern from the client's point of view of the legal cost. But in China, it's a well-established practice in dispute resolution area that the Chinese clients, they prefer the contingency fee arrangements in almost all the important or large amount cases. And also, the Chinese lawyers, they seem happy with these agreements, this kind of arrangements, and they are willing to make a fee quote on the basis of contingency. So in most of the cases with big dispute amount or of great importance to clients, so they will, I think of course, some of them may have, even they have the concern or the pressure of legal costs, and the client will shift it to, or at least share with the lawyer about the pressure, about the burden of legal cost. So it seems that the Chinese lawyer are willing to share the risk with their clients. In China, we call it, we are in the same boat. You win, we win. You lose, I lose. So that's one of the difference between the Chinese market and the other market, other jurisdictions. And the second is the procurement process of legal service. In China, especially for the SOEs, the state-owned enterprises, and even some private companies, in case of litigation arbitration with big amount or of importance to the clients, almost, or most of them, if not all, they will choose the lawyers by a public bidding process or some process of similar nature, like competitive negotiation, like that. And then there will be an evaluation committee, consist of personnel from different departments of the company, or even from the panels of the government database. In that process, which means the founder, as Liang Yu just mentioned, of course, the founder wants to exercise some influence upon the case, upon the lawyer choosing process, upon the analysis of the case. But if in the public bidding process, it's very hard to invite the founder to be a member of the evaluation committee, which means the founder may have less say or have less influence upon or in the process of decision-making process. You almost have nothing to say about the lawyer choosing process. So this is another challenge for the founders, okay? And the third one is the legality of the TPF agreement. Of course, I think that my panelists will explain a lot, but my point is that the TPF agreement, China is not a case-precedent country. So either the court decision or arbitration decision, arbitration award, they are not of course, or not have the strict or very much abiding authority for the other cases. So in TPF, as far as I know, if I were judge, I will review the TPF agreement, not only by its name, but also by its contents. It's in the name of ATE, after the event insurance, whether it's supervised by the relevant authorities, or it may be in the name of a debt transfer agreement, and they should be treated as an AMC business. And that it can be shown as a conditional known agreement without recourse, and it can be supervised or management by the other relevant government authorities. And if it is a foreign funder, then it may encounter sometimes the foreign control, foreign exchange control problems. So a lot of problems, So it's hard to say there's a case there, there's a case here. Then you can judge, so the TPF is accepted or is not accepted by Chinese legal community. So it's hard to determine. So, okay, then finally, so I think it's one of the most difficulty for the funders, no matter domestically or internationally, it's the enforcement procedure in China. Every practitioner in China knows enforcement of valid arbitral award, a court judgment is not effective. If I'm saying it's difficult, okay? So to enforce a judgment is a very, very time-consuming and it's not that effective. That's why the funders, okay, they said that, okay, they will get their successful fee only if the clients had recovered their proceeds. But so in China, if you win an arbitration or even win a litigation case, then it will take another 3 or 4 years to have the award or judgment be enforced. But after 3 or 4 years waiting, then you may finally get an order from the court to say the enforcement procedure is terminated without any outcome. So it's actually in practical, what I mentioned just now is the real practical challenge for TPF. So what I said just now is just for the consideration of all the TPF funders, in developing and promoting their business in China. Of course, as a lawyer, I think TPF is a good thing. We really welcome this kind of mechanism, come to this market especially in nowadays and in the near future. Because to be very frank, as a lawyer, as the managing partner of such a big law firm, we are under a very high pressure against our default clients. Even we win the case, even get the judgment of enforced, our clients do not want to pay us. So this is a bad economic situation. So if we have TPI funders, we're much more relaxed in this part. Okay, I'm sorry. So I hope I don't occupy too much time.
No,
okay?
you were right on spot. So Tao, my basic conclusion from your remarks is that you would be an excellent third-party funding managing director. No, and I say this seriously because a third-party funding managing director needs to have a high degree of skepticism before every case. If a case is a good case, the case would convince you. If the lawyers are the right lawyers for that case, the case would convince you. If the opposing party is an opposing party that has the capital to pay the damages that you see could be awarded, the case would convince you. Otherwise, the case would not convince you. So you would make an excellent managing director of a third-party funding. There's a couple of things that I would like to say here that you have touched upon very quickly. Risk sharing is indeed a feature that I understand is present in Chinese legal culture. Some funders require that level of risk sharing by firms and by funders. The process of procurement within SOEs, I have never evaluated a case against China or against a Chinese company or for a Chinese company. But what's interesting here is that my understanding is that funders look into good counsel. So if the procurement of good counsel is one that is strict and that would get the best counsel, possibly the funder might like that counsel. If the counsel is mediocre, most likely funder would not like it. And last point, who chooses a funder is a key one. I would like in really 3 minutes, Chi Chong and I would like to make an effort in 3 minutes to respond to some of the concerns that Tao has put on the table, because I think that this exchange is very, very good, not only with respect to funding, but also with respect to the characteristics of the Chinese market. But you will only have 3 minutes.
I will try my best to be quick. Yeah, I think just some immediate thoughts on that process. I think ultimately choice of counsel is up to the client. Client has full control of that, and in most jurisdictions that is the position. We would give our recommendations if we believe, say, the legal team that the client wants to use is not appropriately resourced or not appropriately experienced in those particular types of disputes. But ultimately, that's the client's decision. And we pay the bills, and of course, we want the best possible legal team to do it. And we are aligned with clients in the sense that we want cheap and good. So we also like it when law firms like KWM decide that they want to go a bit on risk as well. That will be a good indication to us that they believe in the strengths of a case. So that is something that that we get. I think one of the hurdles that Huang Li Shi talked about earlier, which was the fact that there is a procurement process that we that this process, you know, usually is a competitive bidding process. I think we've seen that feature the number of the cases that we've been working with Chinese parties as well. Ultimately, I think it can work a few ways. It could be that the SOE requires a competitive process in the selection of the law firm. The law firm decides that they want to work with one particular funder, and different law firms have backings of different funders. That's one way to do it. The other way is really once the legal team has already been determined, then the SOE, say for instance, decides that it wants to tender out this process to look at different potential funders that they can work with. That's something that we are not averse to, and we understand that the procurement process actually, to be honest, is not very different from how it works in other jurisdictions as well. Most companies require 3 codes, for instance, on how to approach that. And that's not something that we shy away from and that we are not afraid of. I think what we really want to, I think in my experience, is that once the clients decided to go with one particular funder, we hope that we agree with a sketched out commercial terms and commercial structure with the client. And once that's agreed, I think then we do a more in-depth due diligence to cover off the many different considerations, right? Like the merits of the case, how good the case is, the recoverability, look into the asset position of your counterparty, develop the asset tracing, the enforcement strategies. That's something that we would at least sometimes require an exclusivity period to look at, and sometimes that's a bit of a struggle for Chinese clients to understand. But I think in most cases we can overcome that, and as I mentioned, we've funded PRC SOE in that case that was mentioned earlier, that one that was they tried to set aside in the Beijing courts, and we succeeded. That in that case was ultimately a PRC SOE. So we understand the considerations and the processes and the thinking of Chinese parties and Chinese SOEs in particular, and the many different considerations that go into any decision on whether to use third-party funding, work with lawyers on the contingency fee, and we also understand the cultural nuances in that process. Yeah. Did I cover the questions?
Thank you so much,
Jose? Yeah.
I think that you answered most of the questions, and those that you did not answer, we will leave for posterity. So
Thanks.
now, I would like to welcome Mr. Yu Yao, who is a partner at Huao Mao and Gi Gu law firm, and pick up on a question that was also put together by Tao, which is the notion that, well, there may be the Shanghai court that had a negative ruling, but there were other courts that had a positive ruling concerning litigation. And on top of that, there may be other courts that have a favorable perspective, not concerning litigation funding, but arbitration funding. So could you help us to understand whether this has some logic, given that this is not a common law country, and whether there is some value on that, and I say this with the highest levels of respect. I am also a civil law lawyer as you are. So please go ahead. Yes, please.
Right. So first of all, really appreciate the question, and it's a very interesting topic to discuss the development of third-party funding in China. And it's an even pleasure to join the panel and following the discussion. So just a quick reply to the question regarding the cases. So in my presentation today, we'll also touch upon a judicial approach, which is mainly further discussion regarding the 2 landmark cases brought by Ms. Wang Heng, and also has been mentioned by Jose that because until very recently in 2022, we saw the several cases relieving the Chinese judicial position towards third-party funding. But I will start with a little bit background on the arbitrational institutional approach. I really want to mention this because it will demonstrate potential needs of the Chinese arbitration user in mainland towards their, in order to relieve their burden of the potential cost of arbitration. I also echoed with Mr. Huang has already said that the arrangement of contingency fee in Chinese lawyers' practice also help a lot to relieve the client's burden on the legal fees from the attorney side. But when we look into the number of the statistic posted by the arbitral institution, we see not only the total amount of the dispute and cases in arbitration are increasing every year, but we also have more and more very high value cases. Like according to the 2023 state statistic, we see major institution in China, we have for dispute amount is more than RMB 100 million, there are about 150 to 200 cases. And for dispute amount more than 1 billion RMB, there are about almost 20 cases here every year. So in order to provide a better service to the arbitration user. Actually, arbitrational institutions, they have already done a lot of efforts on this. On one hand, I think they're trying to put some limit, some cap on the arbitration fees. Like BAC, they have their limitation on institutional fee to cap on 7 million RMB and the arbitrator's fees 18 million. Similarly, efforts have already done by CTEC and other institutions where CTEC has put a cap on the arbitration fee about 15 million RMB. That is one hand. However, for another hand, of course, it's come to the funding tools available to the parties where we see even in almost 7 or 8 years ago, we have institutions start to revision of the arbitration rules and promoted new rules regarding third-party funding related arbitration rules in their institution. So having this as a background of the Chinese arbitration market, for my personal feeling, because I used to work in a CTEC as a case manager, even 10 years ago, I started to touch upon the issue in third-party funding because the Chinese arbitration institution, they really have very sensitive regarding the market. Like in the first time I heard about the third-party funding in China, it's almost like 2015 or 2014, it's almost 10 years ago, and we also see a lot of successful domestic funder in China. And till now, like I said, only recently the Chinese judicial has also started to post their gesture towards funding activity in arbitration and litigation. So I will back to talk about those two interesting cases. One is Beijing court case, another one is Shanghai case. Like Ms. Wang has already mentioned, it seems like there is some counter decision because the Beijing court case is a very positive decision towards arbitration funding where the involving of third-party funder in arbitration procedure will not invalid a arbitral award. However, in the Shanghai case, it seems like have a very negative conclusion because finally the court has invalid the funding contract in litigation. Well, however, from my approach, I would not simply categorize those two cases, the difference between arbitration funding or litigation funding, because there's actually a fundamental difference between those two judicial procedures, because in the Beijing case, it's a purely arbitral procedure issue. It's only a judicial review procedure over an arbitration award issued by CTEC. It's an arbitration law issue, it's a procedure issue. However, actually in the Shanghai case, it's a totally domestic contract dispute between the funder and the funded party where all the authority they used relied in that Shanghai case is the Chinese domestic civil law or the old contract law. So they're actually comment to the two funding practice from a totally two different approach. And for the Beijing court's approach, actually, I would say the positive conclusion on the judicial review process to that award is a positive comment. It does not surprise me at all, because when we talk about judicial review process in China in the past 5 or 10 years, we have to mention there is very important background on the SPC, Supreme People's Court, that they have already demonstrated their pro-arbitration approach very clearly from the several cases and from several important judicial interpretations and some internal reporting system requirement for their judicial review process. So I'm not surprising at all to see the court support the arbitration award, even involving with funding practice there, so long as everything, the funding practice in the arbitration in CTAC has followed the regarded rule and the corresponding regulation on the disclosure obligation to avoid any conflict of interest and to follow the duty of confidentiality of the parties. So in that scenario, and also involving with a very professional funder as Omni in that case, I think there's not a big issue really from the judicial approach to trying to find any legality or illegality issue in that arbitral proceeding. However, in the Shanghai court case, it's totally different. It's a very controversial issue because this kind of litigation funding contracts probably could vary first time or only one of the several times exposed to the Chinese judicial on their decision to see whether there is a valid contract. Although the result is negative, but when we look into the reasoning of that judgment, I don't think it's really a negative gesture towards litigation funding in China, because even though we could split the reasoning of the court by two major parts, one part is really a commentary by the court over the litigation funding practice. They thought it's a financial nature and they should be regulated by the financial regulation in China. However, of course, we are lacking of any financial regulation over this kind of funding mechanism. So in this scenario, the court only have a conclusion that, so we have to be very careful. We have to be more prudent on decision of this kind of funding contract. It doesn't lead to automatic invalid contract. What's really a big factor or special factual background kicker into this Shanghai case is the second part of the analysis, which is there is a really close relationship between the funder and the counsel of the funded party, where it's like the controller of the funder is also a partner in the firm who is representing the funded party. And that is really make a difference and draws a lot of the court's concern on the public policy perspective, public interest perspective, including there's potential over controlling over of the party by the funder regarding their litigation rights, like a choice of lawyer or even resolve their dispute outside the litigation procedure. And also there could be a potential malpractice between the funder and the counsel. So I saw my time is almost up. So I will just quick wrap up by 3 takeaways from the observation from those 2 interesting cases, and also what our mainland institution has already done. So the first takeaway would be, I would say, it's kind of optimistic regarding funding in arbitration procedure. One is that the Beijing court decision is really a milestone standing there. If you follow all the regulation following the arbitration rule inside the arbitral proceeding, there could probably no problem as a procedure ground to challenge an award. So the legality of the award could be protected even with the involving of funding mechanism. And the second, it could also be a question for now, but I would say the litigation funding and arbitration funding mechanism could be differently from a regulation approach. Although those two cases are the difference between litigation and arbitration, but I don't think that make a conclusion to see that it's enough to show that we must have a different regulation towards litigation and arbitration funding. However, I do think arbitration in China, having the background by the SPC on their pro-arbitration approach and having the arbitration as a multi-layer dispute resolution mechanism, which is strongly supported by the central government, and also make reference to other jurisdictions like Hong Kong. They have their special regulation, especially on arbitration funding. I think it's probably also a way that China mainland can make a reference to. And the last point is that I think it's a regulation towards funding activities should not be only on the financial industry, but also a combination with the legal industry, probably including with practice on lawyers' side. So that makes my conclusion. Thank you.
Thank you very much. Thank you very much. And last but not least, after you, Zhao, I would like to welcome again Amy, Wen Wei. We're taking on this panel the perspective of one China, two systems, and that's why we are giving a close look, perhaps a summary look into how is litigation and arbitration funding in Hong Kong. So Amy, please. You have just a few minutes, but I know that you're up for the task.
Thank you, Jose. And I am conscious of time, and I'll try to keep my presentation brief and concise. It's a very good thing that my presentation follows that of Yao Yu, as I'll be giving a different perspective. I'll take the audience now to Hong Kong, which has been and remains one of the most important forum for dispute resolution for Chinese parties, especially if they're engaged in foreign-related business transactions or commercial contracts. And I'll be briefly looking at three areas. I'll start with a very brief survey on the practice of dispute funding in Hong Kong in general, the legislative landscape, to be followed by the relevant provisions of the leading non-mainland Chinese institutions and their rules on litigation funding or arbitration funding in general, and how that differ from the overview that we've just seen from Yao Yu's presentation. And finally, a very quick view on third-party funding in investment arbitration, which has gained more momentum and attention in the past few years, especially with Chinese users. Before that, a very quick word about my own background. The first half of my professional career was dedicated to investment arbitration, and my firm represented exclusively state clients. So we're very used to working with state governments, SOEs, public entities. We also represented local municipalities, so we're aware of the particular situation, the relevant constraints, and the particularity working around with clients with a state background or is a public entity. And that could also tie into the attractiveness and also the challenges faced by these entities when they're trying to procure funding for their cases. So a quick overview about the landscape in Hong Kong. Hong Kong is primarily a common law jurisdiction. So that's the major difference between the legal system in Hong Kong and China. And under common law, there are two legal doctrines, one known as maintenance, the other one known as champerty. And these two doctrines, in principle, prohibits funding of litigation in front of Hong Kong courts. So very briefly, Chi Chung gave you the definition of third-party funding, and that's basically precisely what the doctrine of maintenance is trying to prevent. So the doctrine itself says that a third party that does not have an interest in the action itself or is not otherwise involved in the action is prevented from basically sponsoring or encouraging, assisting the party bringing the action by means of, for instance, providing financial support. And champerty is a type of maintenance. It basically prevents a party from having a share in the proceeds of the litigation, and the party is otherwise not related to the action itself. So as a result of these two common law doctrines, litigation funding in Hong Kong is in principle not allowed, saved in very limited circumstance, which I will not go into detail. So that's the legislative landscape and why litigation funding in Hong Kong is commonly not seen. Founders are not involved in this area, and that has been rather established law. It's a different landscape when it comes to arbitration, and even before the law reform in 2019, we see a lot of cases, arbitration cases being funded, and especially if the seats are outside of Hong Kong. And the Hong Kong government were very much aware of the situation, and the law reform, which took into effect as of 1st of February 2019, basically solidified the practice that arbitration funding for arbitration seated in Hong Kong is completely legitimized, and which also shows the government's pro-arbitration attitude in general. And that has been gaining momentum in Hong Kong since then. And what reflected the legislative attitude and the general practice of dispute funding is also something we can see in the original arbitration rules. So just now we look at the rules of some of the leading Chinese institutions such as CTAC, BAC, and now we'll switch gears and look at the HKIAC for a change. And this is the Hong Kong International Arbitration Center, which is one of the leading institutes regionally and also is quite commonly used by Chinese party. So the HKIAC published its latest version, the 2024 rules, just a few weeks ago. But today we're looking at both the 2024 and the 2018 rules, which are largely the same when it comes to third-party funding. So the practice itself is expressly recognized, expressly provided for under the rules. And what goes with it is basically a very strict disclosure requirement, which is found under Article 44 of both the 2018 rules and the 2024 rules. What it essentially says is that the party that's being funded, be the claimant or the respondent, has an obligation, and it's an active affirmative obligation, to disclose the existence of the funding agreement as well as the identity of the founder to the tribunal, the opposing party, and the administrating institution as soon as the agreement is concluded. So if you're a claimant and you have secured funding agreement before commencing an action, you need to announce the two sets of information in your notice of arbitration already. If you're the respondent being funded, you need to announce that in your answer to the notice of arbitration, which is the first written submission that you will provide in the proceeding. And if a party procures funding agreement after the commencement of the arbitration or throughout the arbitration process, which we see happens from time to time, and then the party being funded is under an obligation to notify the tribunal, the opposing party, and the institution as soon as practical after the funding agreement has been procured. And that's, I'm quoting from Article 44 of the HKIAC rules. What goes with the disclosure agreement is also provisions regarding confidentiality. So for arbitration seated in Hong Kong, and by virtue of the Hong Kong Arbitration Ordinance, arbitration proceedings are confidential. So normally a party is not entitled to disclose confidential information or documents obtained through the arbitral proceeding to third parties. But under the HKIAC rules, you have an exception which is provided in case of procuring funding agreement. So as we've discussed, before a founder decides whether or not to fund a case, it needs to be able to access the information of the case and form a preliminary assessment of the merits, the validity of the claim, and also recovery possibilities, which require the funders to access confidential documents. So that's something also provided under the rules itself, and parties would unlikely have a dispute about this particular issue. So that's the rules of the HKIAC. Another more commonly used institution is the ICC, the International Chamber of Commerce. And in its latest rules, that's the rule from 2021, under Article 11, you have a similar provision. It's less comprehensive in a way as compared to the HKIAC provision, but the gist is the same. And the party being funded is under an obligation to promptly inform the opposing party, the tribunal, and the institution about the existence of funding agreement as well as the identity of the founder. The key consideration here is to preserve the integrity of the arbitration proceeding, as the funding agreement itself can impact cost decision, for instance, or the tribunal's consideration when granting security for cost, as we've discussed. And more importantly, it could potentially raise conflicts issue. And that's an important part because going back to the presentation of our previous panelist who mentioned that the founders are not only there to provide funds, but also expertise, and the founder could be involved in the selection of lawyers, experts, etc. This could potentially, and depending on the specific funding agreement, raise issue as to whether or not that creates a conflict within the legal representations team itself. We're all aware that as lawyers representing a client, we were not, and again, depend on the jurisdiction, the lawyer is subject to the regulation and may not be allowed to have an interest in the proceeds or the outcome of the litigation. So before securing funding agreement, we always advise the client or any individual interested in this procedure to carefully seek advice from your counsel and to have this discussion with the founder to make sure that you're not overstepping public policy issues or potentially risk nullifying the funding agreement or even jeopardizing the entire arbitration procedure. When we go a bit more expand into the region, we also survey the rules of SIAC, that's the institution in Singapore, as well as JCAA in Japan, KCAB in Korea, LCIA in London, and SCC in Stockholm. These institution rules for the commercial arbitration, they are for the time being silent on third-party funding. We haven't identified cases where the position has been taken that third-party funding is not allowed or prohibited or restricted in any way. However, there's no express disclosure agreement under these rules, save for the policy of the Stockholm Chamber of Commerce, which recently adopted a policy which encouraged party to disclose the existence and identity of the founder for the precise reason that I just discussed. Things are a bit different when it comes to investment arbitration. And again, we're now talking about cases that in general takes longer to conclude as compared to commercial arbitration. They're usually more complex and the enforcement procedure could be more cumbersome. And when it involves sovereign assets, it could run into potential immunity issues. So this is another area where I would say Chinese users could be more interested in potentially consider using funding agreements either to facilitate and aid them during the arbitration process and or during the enforcement stage once they procure a favorable award. And here, if we survey the major investment arbitration rules, and then you would find third-party funding being mentioned one way or the other by the leading institution, as this practice has been used for many years. And in the exit rules, for instance, the parties being funded are under an express obligation to make disclosure, and that is both to guarantee the integrity of the arbitration proceeding itself, but also to allow the tribunal to take it into consideration, not only when allocating cost and legal expenses at the closing juncture of the proceeding, but also when a party applies for security for costs, which is more often seen in investment arbitrations. And we have case law.
Amy, I mean, I think that those are wonderful concluding remarks, especially how you were able to prove specifically that, I mean, I would even call it sort of jurisprudence constante now, the fact that in every center, both investor arbitration and commercial arbitration, there is a duty to disclose, and that has, of course, ramifications in many aspects, both investor-state and international commercial arbitration, as you have mentioned, security for cost. I think that was a wonderful way to set the stage as to why there is I would say, a clear rule of transparency on who the funder is, which protects the integrity of the tribunal. I would like to conclude simply by emphasizing that, as we have seen, there are many clarifications that have been taking place both in Hong Kong, but especially in mainland China concerning third-party funding. My understanding and suspicion is that there is more to come from courts in the near future. My understanding is also that that this panel has been a great sort of overview and opening for both clients, lawyers, funders, as to what may be the concerns of lawyers, what may be the interest of funders, and how to approach the topics. I really want to thank each one of you because you have done a remarkable job in terms of explaining in a transparent manner what is third-party funding, specifically in China and Hong Kong. And I would end up simply by saying that third-party funding, counsel, and client is like a three-way marriage. If it doesn't work, it's a mess. But if it works, it leads to great results. I'd like to share an anecdote. We had as counsel funding for a party before the JCAA, and it worked out very well. Not only did we win, we got damages, but also the expertise that the funder brought for our case was very useful, and it was always respectful of decisions of counsel and also of decisions of the client. So with that, I would like to conclude and ask for a good round of applause for our panelists. And we are going to conclude. Both Ian and I will just share a few words. I know that you have been incredibly patient, and before simply finalizing our China World Arbitration Update insight, it is really important for us to give thanks to everyone here, starting with the technical team, Fulunda, but perhaps I should start with the BAC slash BIAC. We have been doing this for the first time, and the logistics and the substance has been impeccable. Behind all these 2 days, there was a huge amount of preparation going back to, I would say, almost a year. And behind that, there's also the work of the speakers. There's a travel of the speakers who have gone from Canada, they have come from Mexico, they have come from Hong Kong, from Sydney, so from so many places, from Colombia, etc. So thank you for the speakers. I would also like to thank to the Fulunda team, which have been also impeccable. They're volunteers. To Cecilia. And also, last but not least, I would like to thank especially to the World Arbitration Update executive team, Maria Camila, who is here, who has been doing a very patient and persistent job, in addition to providing quite a lot of substance to the meetings in her own presentation, and also on the remote team that is now in South America, both Maria Lucia Casas and Maria Alejandra Suarez, and also the prior people. Also thank each one of our sponsors. So our sponsors, Huamao Law Firm, as well as Dentons, as well as our platinum sponsors, Globe Law Lawyers and Tiger, and as well as our gold sponsors, Double Care, Dahua, and apologies for my Chinese, the Deheng Law Offices, Global Law Office, Yuan He 12 Tables, and I would also like to give special thanks to Brilla, of course, Fulunda, and Lex PR, as well as Fly Tech and technical support. If I have missed anybody, I apologize. But what we really want to do is to put a flag, hopefully here in Beijing, and really welcome you to the. Hopefully next year we'll be able to come back to China and do another World Arbitration update. But you have an immediate invitation, because China World Arbitration update is the beginning. As tired as you may be, is the beginning, because on Monday we have World Arbitration Update Washington, and we are doing this from 5 other jurisdictions, sharing with the world the particularities in international commercial arbitration and in investment arbitration from those jurisdictions. So you're welcome to join in a challenging calendar and time, because now it's, I don't know, almost 6 o'clock. So in those jurisdictions, it might be 6 o'clock in the morning. So, but you're welcome to join us at the real time. Okay? And thank you very much.